Our last and final card is Brad Deacon from the Michigan Department of Agriculture. Thanks for joining us.
Thank you, Mr. Chairman and committee members. Appreciate the opportunity to be here today. Derek Badgema sends his regards, but had a family emergency, so had said that we would come back and respond to some of the things that the previous speakers from last week have said. Just in brief, that the law has not changed. There has been a lot of there were a lot of media stories and certainly a lot of social media stories. As you all know, the Right to Farm Act didn't change because it didn't come through this committee, and there isn't a bill to change it. The GAAMPs are not rules; they are not regulations. In part because the legislature has not told us to do rulemaking. The legislature directed us in the Right to Farm Act to do GAAMPs, which are the generally accepted ag management practices. One of the speakers from last week referenced the Senator McManus Task Force, the Senate Ag Preservation Task Force from 1999. I was around then. I went to a number of these hearings and was then the legislative liaison for the department when many of the bills to implement what was in the task force recommendations were going through, including Senate Bill 205, sponsored by Senator Joel Goujon. Talked with him last year about this and to get his recollection about the Right to Farm Act and the contentious hearings that the legislature had at the time, the last time that we've amended the Right to Farm Act, and he remembered it the same way that I do, that the hearings brought out the real concern that townships and in some cases counties were trying to zone agriculture out of existence out in the countryside, and that's what Senate Bill 205 was all about, those amendments, and that it was not about directing cities to let agriculture go wherever anyone wants it to. The initial GAAMP for site selection was something that the department was obviously very involved in with the commission, and we did focus on what was the main issue at the time, which was where does large livestock go. But if you look at the Right to Farm Act, it doesn't say create a GAAMP only for CAFOs. It says by May 1st of 2000, the commission shall issue proposed generally accepted agricultural and management practices for site selection and odor controls at new and expanding animal livestock facilities. There's no definition that says that is only large, but as that was the big issue at the time. So that's where our focus was. As times have changed and we have seen more conflict, particularly in densely urban populated areas, that's why we have come back around, and the commission has been working on this, as you know, for 2 years to look at and say our previous category 3 wasn't sufficient, that we needed to have a fourth category to say that in some areas some areas are not well suited for livestock, some areas are very well suited for livestock, and now instead of 3 categories we have 4. In the category 4, we feel because that there are a lot of people around, and if there are 13 houses within an eighth of a mile, you have a lot of neighbors. And as the previous 2 township supervisors have said, those neighbors also have expectations. From our standpoint, the cities like Grand Rapids and Petoskey have looked at this and debated it actively and then said, no, we don't really want livestock in town. And from the Ag Commission standpoint, from the department standpoint, to say that a ring of neighbors has no say, and the local unit of government has no say if someone decides one day to bring home some goats. That kind of discussion should happen, and should happen through the process, as Senator Emmons was asking about process. That is a conversation that in densely populated areas should be inclusive of the people there. So with that, I mean, I'm happy to answer any questions. And
my first one is to piggyback on an issue that Senator Brewer mentioned earlier. Bees. Were there any GAAMP Are these GAMP changes, do they reference bees at all? I know address livestock. Are bees considered livestock? Can you address that specifically?
Sure. The site selection GAMP has never considered bees as livestock. Bees are included in the Right to Farm Act. They are in the list of farm products. But from a legislative drafting standpoint, when farm product lists a whole series of things, it lists bees and bee products and then separately lists livestock. So we have interpreted that, and although, Mr. Chairman, we would be certainly able to go back to the citing committee and ask for some discussion about bees, because as opposed to many other types of livestock that don't get out or shouldn't be out, bees inherently will not stay on your 1 acre property. So there are many people who don't like bees, and so they are included in the animal care GAMP, but they have not been included in the livestock GAMP, in the site selection GAMP.
Thank you. Senator Evans.
So help me clarify for me, because we've heard a lot of things in the last hearings.
Yep.
Generally accepted agricultural management practices, GAMPs. Are they voluntary?
Yes. Yes, the GAMPs are voluntary. The Right to Farm Act is a nuisance protection statute. So if, and as was indicated by the Court of Appeals twice now, if you want to claim right to farm protection, the burden is on the person claiming it to show that they are in conformance with GAMPs.
Senator Booth.
Thank you, Mr. Chairman. I'm allergic to bees, so that's probably why that comes up for if I had a swarm of them or two next door. But the issue, you will go back and look at that particular piece of it, get up with bees.
Yeah, we can go back to the commission and to the citing committee to talk about whether bees really should, whether there should be specific requirements if you want to put a hive, because if you put the hive on the edge of your property line and all those bees every morning zip onto your neighbor's property, and that could be a nuisance situation.
A lot of the farmers need bees. They
Yes.
need bees, and they
Yeah.
back right up to these subdivisions. And if I can put, I would say 100, more than 100 hives on an acre. More. I mean, they stack them and put them in there, and a lot of us need them, I mean, for our crops. And so if I wanted to try to make some money, I only lived in the subdivision, I only had 1 acre, but I did have an opportunity to make money and help the farmer too. And I think probably the clarification of that. I think one of the parts that also I heard last week was that if I have, I'm covering the right to farm in the residential area because it doesn't have a house on it, 1.8 acres, it doesn't have the right number of houses in there. If somebody comes in and moves in and builds a house in there, now I lose my protection because I do have more dwellings in there than the law allows, or the GAAMPs allows. I mean, what if they did? And what happens to me? I can't just automatically stay in it because there's more houses that will allow me to be there.
That's an excellent question, Senator. Like all of these citing questions, they are site specific. But if you're operating and have a farm operation, and then subdivisions pop up across the street, or the neighboring farm goes out and houses get built there, that's exactly why the Right to Farm Act was created. If you were there and operating, you're pre-existing, what we would say that you may not get GAAMPs protection if you want to turn that 40 cow dairy, like the one that I grew up on, If now there are so many neighbors around, we might say, no, that is not a good site to turn that into a 4,000 cow dairy. But the existing operations, yes.
If somebody came in and built another house and that took me out, I mean, in the numbers, I'm already in it. And somebody builds another building, and now I don't qualify to have the protection of GAAMPs. They built in there.
No.
And I was okay under the way it was prior. But if somebody comes in and builds another house, now I don't. Do I just automatically not get covered? Or do I stay covered because I was doing it before? I'm not talking about expansion. I'm talking about...
If you were doing it before,
Yeah.
and more houses pop up, then that's exactly what the Right to Farm Act has always focused on, was when people move towards the farm to protect that farm operation so that the farmer has the ability to continue doing what they've been doing. Under the site selection GAAMP, we may say, no, you may not really be able to expand there because of the neighbor pressure. And that's a fundamentally different thing than someone who has 13, 14, 15 houses nearby and decides one day to bring in a livestock operation. I mean, those are two very, very different scenarios.
Well, and Mr. Chair, I'm just specifically saying if I'm raising 20 rabbits under present conditions in that subdivision, and I'm protected, if another house is built and it takes that, my protection off because I don't qualify now. I'm not expanding, I'm not doing anything. Others, I can't do it anymore. So if the GAAMPs protects me still, then that's fine. I guess, I mean, that would have been my worry, that in fact we would not have that coverage now.
How would that be investigated? How would, do I have to substantiate that or show proof that I started my rabbit herd before the maximum number of houses were built in my circumference? How do you?
Well, again, very site specific, and this is driven only if there's a complaint. There are approximately 20,000 livestock operations across the state, and we, in the history of Right to Farm, have only gotten to a couple thousand of them. And those have been because there have been complaints, because there have been nuisance issues. We have done some proactive where people, but those are generally larger livestock operations where the farmer has a significant investment in terms of building a structure, and before doing so wants to check to make sure that that would be a good site. For the scenario that you're describing, first off, are you in Category 3 or Category 4? If you're in Category 3, then if you're under 50 animal units, you're good to go. There isn't a need to do a proactive. You don't have to go through siting. If you're in Category 4, you may have been there before, like you're talking about. If you're what is now Category 4, if the person had rabbits, had chickens in their backyard, and if they were as supervisor from Williamstown Township said, there are plenty of places where there may be 13 houses around where local zoning lets you do agriculture, and that continues. That hasn't changed. The state hasn't changed or taken any of that away.
Any other questions or comments? Don't leave yet. I want to pontificate a little bit. There are no further cards on this issue, but I was growing up, and the only thing I ever dreamt of was being a farmer, ever, and I thought that was the best thing, and we still love to do it today. Until about 10 years old, my parents lived on just a 2-acre plot, and I was so fortunate that they were supportive of all of my farming habits, and I acquired way too many different animals on a 2-acre plot. Fortunately, I bought a farm just a year or two later. But, and fortunately, we had understanding local government. And I'm sympathetic to the plight of the folks that were in opposition, not only scared and worried about what's going to happen to their small ventures or larger ventures, but I want to direct you at the department, either to the director or the Ag Commission. I think a reasonable thing to do would possibly be putting together a work group, a task force of all stakeholders, the folks that were in opposition as well as the folks that were in support of the changes, to see if there's a consensus we can come up with. I want to be a part of it. In fact, I will be a part of it.
Okay.
If there are other legislators on this panel or in the Senate or House that want to be a part of it as well, let's see if we can get some consensus to make recommendations to this panel and also potentially make some additional recommendations to the Ag Commission. Can you take that back, or can you agree to that now?
Absolutely, Senator. That is something that the director has been thinking about as well. I will take that back to her. She wasn't able to be here today, but she is aware that there needs to be some continuing dialogue in this area.
Great. Well, let's plan on that. And I don't know, let's make some public statements, either myself or the director, maybe as late as early next week, to have folks contact either my office or yours to figure out how to become involved in this discussion process. And within anything else the committee members want to mention, Vice Chair Brewer.
Thank you, Chairman. That's a great recommendation. I really feel strongly about it. We didn't have 40,000 names turned in here for nothing. There is a real concern out there. I mean, so whether they checked off or how they got those names, but I know there's 1,250 of those in that pile from my Senate district. So, I think if I come back and tell them that there is something happening like this work group, that would be very beneficial to me and probably to others. I don't know if you check those, that's that, but I think it would be very important for us to be able to answer it that way, that there is, and the stakeholders will be involved in this thing. Thank you, Mr. Chairman.
Yeah, and any other questions or comments? One last comment I wanted to make, and then we will adjourn. I could even see myself, I don't know about the members of the committee, supporting maybe an entirely new act, a Right to Urban Farm Act or something along those lines. So let's see if we can get some potential consensus hammered out. I'll talk to the director, and we'll march forward. And thank you for your testimony. Thank you, folks, for being here. Thank you for bearing with us for the second week in a row. And I apologize for the timeline. We were crunched last week. So thank you so much. And without objection, we are adjourned.